Okay, welcome to, I guess this is chapter 13, Criminal Justice Today. We're going to be covering the juvenile justice system today, which is a very unique part of the criminal justice system. It's separate, but a part of a lot of the broader themes we're talking about. So, in some ways, this can almost serve as a review for us because we'll be looking at the apprehension or the detection of juvenile crime, how we adjudicate it, which is the trial sections we talked about unit before last, and then finally we will briefly touch on sentencing um, and alternatives. So the first part, and you're probably sick of hearing this, we have the learning objectives, the things that we'd like to accomplish going forward in this course. And again, you don't have to know most of these directly. These are really just things that we're seeking to accomplish. Okay, so it's always, I think, important to ask a few questions. Um, so here are four or so that I came up with as I was drafting and redrafting this chapter. And the first one is, why special assistance for juveniles? Um, Now, the whole concept of a juvenile is really the creation of the modern world. If you went back to ancient Rome, or you went back to ancient Greece, or Babylonia, or ancient Israel, or ancient China, the concept that there was a unique and special period between being a child and being an adult is not something that they readily embraced. So we created the idea of the juvenile, and then we said, okay, well, let's give them a separate system. So why just them? Why not also the elderly, the people in our society who are our venerated elders? Why not people who are handicapped? Why not veterans? And there are some of these are special courts. So as we examine those questions, or as you examine those questions going through this, keep some of that in mind. Um, why should juvenile records be kept secret? You probably know that by and large, juvenile records are kept separate and apart. They're kept secret. They're not as readily available as others. So, again, why juveniles and why not everybody else? Um, Third question, and this assumes, I guess, the first two are right, and that's what's the best way to treat juveniles in the system? Is the family a better option than the state? What are we seeking to accomplish here? And what other purposes might be served by this whole institution, this whole creation that we brought about? Is there some reason that men in particular, but the poor and minorities, are overrepresented inside the criminal justice system? Okay, there'll be a micro lecture, like for a lot of them. This is one of my favorites, the orphan train. Something I learned about quite a few years ago that I just couldn't believe at first. Um, so we're going to talk about how this really can be used as a tool to understand really the development of the idea of juvenile and how it really changed. And I will at least touch on sometimes they're called Indian schools, and that's a pejorative term, but it's the idea that you are going to take Native American children away from their parents. You're going to compel them to stop speaking their native languages and practicing their native religions because you were going to assimilate them into Americans. And this was not just done in America, this was done in countries as different as Australia and America. Okay, so to return, there's some pictures of the orphan trains. And again, I'll talk more about those in the micro lecture, but basically these were just rounding up people, children, juveniles, and shipping them out west. Okay, where does this movement come from that really comes to fruition in the juvenile justice system and inside these orphan trains? Well, in the 1800s, there was a massive appetite for social change. And part of this, I think, is tied to the way democracy works. Part of it was tied to technology and the changing structure of society. So to give three examples of these large movements that existed in America during this period, we've got the abolition movement, which had always kind of existed in America, but really by the middle part of the 1800s becomes a very vital, very vibrant and important movement. We've got Prohibition, which really peaked later. As a matter of fact, peaked with the idea of the banning of alcohol. We've got the suffrage movement. The suffrage movement was, of course, the equality of women. And this was probably just a little bit after the abolition movement really got going, and certainly existed side by side with it. With all of these movements, with abolitionism, with prohibition, with suffrage movement, we also had the child savers. These were people that looked at the structure of the criminal justice system, looked at how children were being treated in societies, and said this has to change. Now, it's based not on the idea of the individual worth of the child. That would be nice, but that's really not what people were thinking. In many ways, there was still very much a patriarchal idea about children. They were property, they were owned. The substitute here was parens patriae, which is literally the fatherland. Traditionally, the overarching theory of how children fitted into the legal system was something called paterfamilia. And literally the father or the eldest male was the head of the family. And they had near absolute control over children. In ancient Rome, for example, and that's where paterfamilia, I guess, is most easily codified and studied, the father literally could kill his children, sell his children into slavery, could do anything with the children. We also see this in the Hebrew Bible. This was kind of challenged as other institutions grew up, including the institution of the nation state. So the idea that the nation state, the fatherland, was the literal parent of us all, figurative perhaps is a better term there. And so the state had a duty and an obligation to intervene and to protect children. Early on, of course, juveniles were just treated just like adults. They suffered the same penalties. So once you were no longer a child, you were an adult, and we had no problem handling people, extremely young people, as adults. Now, the child saving movement fought this, and they tried to get separate housing, separate treatment for juveniles. So we see the New York House of Refuge, which was opened in the 1820s. And increasingly, a regulatory scheme really is developed in different states to treat young adults, juveniles, different than older adults. The first court system that really codifies this and puts it in place is Illinois. In 1899, the state of Illinois established the first juvenile courts. So this, as you can see, if the House of Refuge is created in 1825 and the Illinois juvenile justice system is not created until 1899, it's pretty evident that this took a while, and it did. It really percolated through society for a significant amount of time. North Carolina was not the first nor the last. The last state really adopted was in 1945, unless you count Alaska and Hawaii, because they weren't admitted till after 1945. So fair enough, I think, to say that they would be last. But North Carolina passes the Prohibition Courts Act of 1915, which establishes dependent and delinquent status. Now, we're going to distinguish those as we go forward. But it's the idea that there is a difference between juvenile delinquent and a dependent. It also set up separate juvenile trials and separate facilities, although we did a little differently. It recognized that children were not fully responsible for their actions, that they were not adults. And this is the real step forward. This is really saying, okay, it's different. And this was fought tooth and nail. Um, there were people that really saw this as wrong, much like the rules against child labor were seen as wrong. There was tremendous opposition to regulations and rules that said you couldn't work children in coal mines and things like that. Well, there was opposition to this juvenile movement. All right, as I said, there's really two broad categories of juveniles. There's what we call today status offenders and juvenile delinquents. Status offending is a newer term than delinquency. But status offending says this individual has committed an act that if you or I did it, because I'm going to assume that most of you are over the age of 18, if you or I did it, it would not be a crime. But it's unacceptable for those under this statutory age to do what they did. So a quick example here of a status offense would be truancy, not going to school. Delinquency, on the other hand, is something that even if an adult did it, it's a crime. So if a 12-year-old beats up someone or steals something, it's not a status offense, excuse me, it's juvenile delinquency. And these are two separate categories. These are really the two paths that can lead you into the juvenile justice system. Okay, the other thing we do is we use different terminology. And this is true of almost any new profession. Anytime a profession decides that it's going to separate itself out, one of the first things it does is it creates a unique language. So in a regular court system, it's a crime. In the juvenile court system, it's a delinquent act. You have complaints in adults, petitions for juveniles, arrests for adults, intake for juveniles, convictions, adjudications, sentencing, disposition. So you can see we use different terms. Now, what gets you there? So this chart, I thought, now this chart's about 5 years old, but it can be difficult to find a lot of data on juveniles, obviously because quite a bit of it is protected. You'll notice that the number one way in which you're going to wind up inside the juvenile system is truancy, is failing to go to school. And that's half of all the people that wind up in the system. These are the status offenses. Then you look at liquor law violations, ungovernability, more about that in a second, curfew violations, running away from home, and miscellaneous. So I've had students say, well, what's ungovernability? And it's very sad in some ways. I've seen it in court, where you can have the parent, often a single parent, down there saying to the court, I want to surrender my parental rights. I can't control this child anymore. This child is ungovernable. They don't listen to me. They're disruptive to me. And I want to surrender my rights to the courts. And that can be seen as a status offense. But the vast bulk, truancy, not going to school. Now, early juvenile justice systems had very few safeguards, just like most early criminal justice systems did. So juveniles, once they were in the system, had very few rights because it wasn't seen as the sort of adversarial competition that regular court is. So there was no defense attorneys. There was no right to present a proper case. There was no right to make bail. There was no right of appeal. And the rationale behind this was, well, this isn't a criminal court. This is a unique hybrid. This is something that's different. And those things belong in a criminal court. What we're doing is we're operating in the best interest of the child. And the system was supposed to help the juvenile, not punish him. But obviously abuses occur. Have occurred, do occur. not too long ago, up in Pennsylvania, I believe, they caught a couple judges, there were two of them engaged in this, that basically were getting kickbacks. The more juveniles they sent to private correctional facilities, those facilities would give them money. And because they had this incentive, they would be sending people that had committed very minor offenses, status offenses, caught after curfew or caught with beer. They would say, okay, you're going to a juvenile facility, which I'll get a check from, whether you don't know about that, for 6 months or a year. So gradually we started to say, well, with these as a later example, since this hasn't been completely admitted, we need to provide some protections for the juveniles. So there were gradual changes. Now, again, this is part of a larger social movement in a lot of ways. You can put the context of the evolution of the juvenile justice system into the same sort of pattern that we talk about abolition and suffrage. Well, the changes in the juvenile system were part of the changes that were going on in the 1960s. You have the famous case of Gideon v. Wainwright, which says if you're an adult and you're going to go to prison, you have the right to an attorney even if you can't afford one. So we have these important cases because you had a Supreme Court which was led by a non-scholarly lawyer. This is the Warren Court. Chief Justice Warren was not a legal scholar. Chief Justice Warren was the former governor of California. Very popular governor. As I recall, he was nominated by both the Democratic and the Republican Party. And he was not initially, by the way, and this is a digression, but you'll have to live with it, he was not seen as a great liberal when he's appointed. If I'm not mistaken, he was appointed by Eisenhower. And Warren was seen as fairly conservative because here's an example of why he was thought that he was going to be more conservative justice. Earl Warren was the governor of California when World War II broke out, and he really led and called for the arrest and internment of Japanese Americans. And I think that probably bothered him enough that he might have reacted against it. So when you look at these cases coming up, they're really part of a series of cases from the Warren Court, a little bit later from the Burger Court. So we have Kent versus the United States, very important decision. This, much like the case of Gideon v. Wainwright, says, okay, if you are a juvenile, you have the right of representation. And you're going to get a hearing, and you're going to get counsel. Particularly if they're going to send you, in this case, to an adult court. Now, in re Galt, which people argue is the most important case, says you get the basic procedural safeguards that you would get if you were in an adult trial. And this is like I said, this is huge. Because until this point, we really didn't give juveniles many of these rights. A little bit later, we have in re Winship and Bree versus Jones. Winship's a little bit more important, but we needn't go into those. You can take a class on juvenile justice. It's offered. I would recommend it. It's an interesting class. But one quick aside here, because I've had this question, and one of the weaknesses of me giving these lectures online is I have to try to anticipate questions students have. So in re, what does that mean? In re is a Latin term which is placed in front of someone's name, and it simply means in the matter of or concerning. So when you see a case that is in re Winship, it means this case is about Winship. In re Galt, this is about Galt. And that's really part of the idea that it's not an adversarial. It's not state versus Galt, state versus Winship, North Carolina versus Jones. This is different. This is in the matter of or concerning. Okay. what age is someone a juvenile? Okay, well, if you recall, when we first started this class, I talked a little bit about the age of infancy. If you are under the age, basically from the time you're born till your 6th birthday, you are an infant under the law. And if you are an infant, you can't be charged at all. You're not even in the juvenile system. However, between the ages of 6 and 16, that was the rules, you were a juvenile. Now, in 2019, North Carolina passed a modification to its juvenile status. So we modified it. We raised the age. We gave additional time to 18 in some cases. But between the ages of 6 and 15, you're almost always a juvenile. When you're 16, when you're 17, and until your 18th birthday, so 17 years, 364 days, it's easier to transfer you to an adult court, but you still are a juvenile. However, it's possible, believe it or not, as young as 6, you could be prosecuted as an adult, and that's kind of crazy in North Carolina, but it's not readily done. It does happen, particularly with violent crimes. There's a tendency to do this, but most of the time, certainly defense attorneys, if they're hired, what we're trying to do is keep things in juvenile court for lots and lots of reasons. Okay, this is your minimum age to be tried as an adult. You'll notice that in North Carolina, you can, in theory, be tried as young as 6 to 8. The ones in lighter blue are 10. The ones in the kind of green, there's no age minimum. Again, it's freakishly rare to have anything that young, but it could happen. Okay, so the second micro lecture after the orphan train, which is the first one, is when is a juvenile not a juvenile? And we'll talk about some of the inconsistencies, and this is a question I get nearly constantly in class from my students. You know, well, how come I can't buy a drink, but I'm treated as an adult? So I'll talk about that in that micro lecture. All right, here's some good news. I want you to go home and tell your parents. I want you to go home, and I remember I said in, I think, the first lecture, you can go home and you tell your parents they're gangsters, that they were bad. But here's something where you can go home and you can say, our generation is better behaved than your generation. Our generation as juveniles are committing far fewer assaults, aggravated assaults, beatings, robberies, rapes, and murders than your parents did. So if you look at the homicide rate, you'll notice that in 1994 it peaks for juveniles right around 15 per 100,000. And you look at it today, it's almost non-existent. The juveniles simply aren't killing people at anywhere near the scope they were. And everything else has gone down. Aggravated robbery, aggravated assaults, rapes, all those are down. So juveniles are committing fewer crimes than their parents. Okay, so here's some trends in juvenile delinquency we can pay attention to. The number of juvenile inmates decreased by 50% between 1997 and 2013. Now, back up for 1 second to this previous chart. So 1997 is when they started cutting the rate at which we incarcerate juveniles. And then if we fast forward to here, you'll notice that the rates are way down. Now that's an interesting bit of empirical evidence, because one of the things that would show you is that prison does not lower crime rates. Prison occurs after the crime. Prison does not impact crime. It's a fallacy. Okay? If it did, if we were less lenient and incarceration rates went up, we should see a decrease in crime. Instead, when we're more lenient, when there's less incarceration, we see this decline. Okay. African Americans, why do we see that decline? Well, we can look at things like juvenile curfews, quality of life issues, local programs. All those are interesting approaches. But let's talk a little bit about race and juvenile delinquency. Again, when you look at these systems, like most of the rest of the criminal justice system, African Americans and African American males are vastly overrepresented inside juvenile delinquency systems. 6 out of every 10 of juveniles who are in the juvenile justice system are a minority group. And that's a pretty shocking statistic. And if you look at male versus female rates, they're even worse. Now, the arrest rates for girls are declining a little bit more slowly. I think that's because we're seeing some different detention trends. I think we're also seeing some tension in society about this. But suffice it to say that still, to be black, to be poor, to be a man or male, all of these kind of stack the cards against you. All right, school and delinquency. And this is something that has been brought up in these recent protests, the Black Lives Matter protests and others. One of the things they've talked about is defunding the police. Well, one of the things that happened, and this is really since the Columbine shootings really set this off. There were a number of things that happened in the late 1990s and early 2000s. Things are rarely triggered by a single event. But after Columbine, we decided that we wanted to prevent mass shootings, so we were going to put resource officers, what we called them, inside schools, police inside schools. They really didn't have an effect on school shootings. They didn't really dramatically lower the rates or stop them. But what they did do was they brought an entire generation into much closer contact with the criminal justice system. So we have a lot of arrests. Once you put one of the things I talk about in this course is I say, if you look for crime, you're going to find it. Well, if you have a cop in the area, he's looking for crime. Interestingly enough, in 2017, statistics I found was that 40% of the referrals into the juvenile delinquency system comes from schools. It's one of the things that has driven the juvenile system. One of the other things that's happened is some crimes have kind of been redefined or reinterpreted. Bullying has emerged as a new concern. So physical, verbal, social, emotional, cyber abuse. And every state has enacted anti-bullying statutes, and North Carolina, not an exception. The link between delinquency and crime. I'm going to use 2 terms here that you should be familiar with. Age of onset and aging out. Aging out is a well-established phenomenon. It's really not something that anybody debates anymore. We know that as people get older, they commit fewer crimes. So what I like to say is crime is a young man's game. If we're talking about violent crime, which is how most people appreciate or think about crime, it has a physical component that is easier done when you're young. If you're a 70-year-old man, an 80-year-old man, a 90-year-old man or woman, it's hard to be a gangster. You know, it's hard to say, okay, I'm going to pop a cap in somebody. I'm going to get in the Tin Lizzie and drive downtown and use my, what do they used to call it? Rod. Believe it or not, they did. They call machine guns rods. This is in the 1930s. I'm going to use my rod to light up the flapper girls. Well, that doesn't happen anymore. You don't have to worry about grandpa committing crimes. You worry about junior. We know people stop committing crimes as they get older. That's the phenomenon of aging out. So there are peak years and then declines. The other thing we like to know is at what age do people start committing their first crime, and what that crime is important too. All things being equal, in particular if it's a crime of violence, the younger a person starts to commit crime, the greater the danger from that individual. An analogy I can give you is smoking. If you start smoking cigarettes when you're 12 and 13, that's really bad, because the odds of you becoming a chronic long-term smoker are very high. But if you don't have your first cigarette till you're 20 or 21, the odds of you becoming a routine smoker are actually pretty low. It does happen, but they're much lower than if you expose children to it. So the age of onset is very important. At what age do people start committing crimes? Substance abuse. Now this is something that is surrounded with so many problems, so many myths. One of the questions I'm constantly asked is, do drugs cause crime or not? And first of all, there are rare instances where being on drugs can cause you to commit an act which is a crime. It's called psychopharmacological crime. It's very rare. It's okay. He was so delusional that he thought his girlfriend was an alien and he shot her. If those are the only crimes that occur, we can all pack up and go home, because that's so rare we don't worry about it. The question we have here is, are drugs causing people to develop a tendency to commit crime? Or are they just a result of people already having innate urges to commit crimes? Is it a causative factor, or is it merely associated with it? And which drugs matter? So, I used to teach at the Raleigh Police Academy for individuals who were getting their 2-year degree, and I got to know a lot of cops. And I can honestly say I never met a cop who was afraid of anybody that was high on marijuana. People that are toasted, people that are baked, interesting that we use cooking terms there, they don't tend to be dangerous. They're not going to be able to find the remote, much less a gun. So they're going to be stuck sitting on the couch watching Adult Swim till 2 or 3 in the morning. On the other hand, there are some drugs that are a little bit different. One of the interesting drugs that seems to have a link to juvenile justice, which again would tend to argue this is a correlation, not a causation, is tobacco. Tobacco use has a high prevalence among juvenile delinquents. But it makes no sense to say, well, smoking tobacco makes you a criminal. Of course, tobacco is not, by and large, illegal. Child abuse and neglect. I will say that of all the moving parts of our system, that if I could stop one, if I could change one fundamentally, it would be child abuse. Child abuse and child neglect. It is, at its core, the hardest part of our society. It's the part of our society that continues to not only inflict that pain and suffering on that child, but 10 and 20 and 30 years later, to take those horrible things they suffer through and have those things come back out. Come back out as a father beating his child because he was beat as a child. A father or a husband beating his wife because he was beat as a child, or he saw his father beat his wife. It's clear that child abuse has very strong roots in the criminal justice system and continues to impact. So what is abuse? Abuse is the intentional infliction of physical or emotional pain on a child. That's child abuse. Child neglect is depriving a child of love, shelter, food, care through negligence. 10% of all children in the United States, which is just a shockingly high number, will suffer abuse or neglect from their family. And the abuse and neglect doubles the chances that that child will grow up and commit crimes. Again, not a direct causative, but more causative than correlative here. A little bit about gangs. Gangs are often seen as part of juvenile justice. So one of the questions is, why do people join gangs? Well, I think there's an innate desire to recreate family groups, to recreate structure. If you come from a very broken home, if you come from a very abusive home, if you come from a neglectful home, you're going to seek to impose some sort of order, and gangs give you that. They give you identity, they give you fellowship, they give you protection. And some gangs are violent and dangerous, and some are not. So gangs are simply 3 or more persons separated from a larger group by clothing, or vocabulary, or both, or signals, or names. And for our purposes, we focus on those gangs engaging in criminal activity. Juveniles who suffer abuse and neglect are much more likely to join gangs than juveniles who do not. Who are the gang members? Well, typically gang members are late teens. There are, there are gang members who join earlier than that, but it actually tends to be a bit later. Now, one of the more interesting things about this phenomenon is about 53% seem to be Hispanic, 32% African American, 10% are white, Caucasian. Hispanics have almost always been overrepresented in gangs, and there's lots of different ideas about why, hypotheses. Nothing conclusive as to a theory or explanation, but clearly it's important. We're just not sure why. Typically, gangs are formed in lower social and economic groups. Now, that's not always true, but it seems to be true. They are urban-based, but we are seeing it expand into rural and suburban communities. They are predominantly male. Very, very rarely will you see female gang members. They're interesting to talk about, but it's predominantly male phenomenon. All right, what about the police? What about 5-0? There are about 500,000 juvenile arrests every year in the United States. When a police officer arrests a juvenile, we're going to introduce a new Latin term here. That police officer stands in loco parentis. Loco parentis is Latin, and it means in the place of the parent. That gives the police officer a lot of authority, a lot of power. More so than almost anybody else in society. So, because you're standing in loco parentis, you can do things you could never do for an adult. You can't say, well, it's really good that you're not out past 10 o'clock. Try telling adults that. See how that works for you. You won't get much of a positive response, but you can tell juveniles that. You can compel them to obey a curfew. The police here are really operating with very little discretion. Visibility. They have tremendous amounts of discretion. I hate to keep coming back because it will date these lectures, but I'll be re-recording them this year anyway at some point. But the police have tremendous power to escalate or to ignore behavior. Now, we recently saw the death of Mr. Floyd. And if you think about that, the police had a choice how to handle that. They had a choice to ignore or escalate that. And their choice was escalation. And maybe that's the correct choice. I'm not going to argue that. But the result was devastating. And for juveniles, police often have the choice. If I see a kid smoking, or drinking a beer, or taking a toke, do I want to interfere? And really, if it's a minor thing, particularly if it's a status offense, police officers have huge amounts of discretion to intervene or not to intervene. If the police decide, we get what's called a referral. So the police usually refer a juvenile to the court system. As I said, about 40% of all referrals come from these school resource officers now. Anyone with a valid reason, including parents, relatives, welfare agencies, school officials, can initiate a referral to juvenile court. Typically, it goes through the police. The police, if they're involved, are going to look at issues like this. What was the nature of the child's offenses? So if it's a minor offense, you tend to exercise more discretion, maybe not charge as often. A serious offense, if it's a murder, if it's an assault, if it's a rape, it's going to get referred. What's the past history? Do they know this juvenile? Do they know that this juvenile has been involved inside the system? Where did this take place? Was it school? Was it home? Was it in the streets? Was it late at night? Are there parents? Are the parents willing to take disciplinary action? What's the attitude of the offender? I can't emphasize enough how many times in the criminal justice system I've seen people talk themselves into trouble. People are, I know I am, innately proud of their independence. And it rankles us to have to accept someone else's authority over us. But being combative will rarely lead to escaping the consequences of your attitude. And by this I mean you just don't see people where they're yelling at a cop saying, "What are you doing? You shouldn't arrest me." You don't see the cop say, "You know, you're right, go home." Maybe in a perfect world, telling them that what they're doing is wrong when it's wrong would get you off the ticket, but that's really not how things happen. Also very important is what's the gender. And we'll talk about the chivalry effect. Intake is formally done by either an arrest or a petition in the court. So the petition is a formal document that's filed that alleges that you are a delinquent or a status offender. Sometimes at this point, and it can be either legislative or prosecutorial requirement, you can be transferred to adult court. Sometimes that's automatic for certain crimes. One of the things that private attorneys are hired for, and I would spend a tremendous amount of time doing, is called diversion. You want to get the case out of the formal system. You want to get low-risk offenders out of the formal system and get them in a community-based rehabilitation program so that there's no record, no conviction, no intake, none of this. The most important thing here usually is restitution. And if it's a status offense, treatment or aid. What we are fearing the most, and what I would fear most for very young clients, is labeling. Labeling is a sociological theory that's well established. And it essentially says once you call something a name long enough, that's what that thing becomes. If you tell a juvenile you're worthless, you're trash, they'll start behaving that way. If you keep saying John Doe is a criminal, he's a bad person, he's a criminal, once that label is attached to him inside the system, it's going to be very hard for anybody else to see anything but a criminal behind that name. Okay. More juveniles are being moved over to adult court. This is part of our Get Tough approach. We have about 6,000 people being transferred to adult court, sometimes by judicial waiver, some by mandate. Now, in North Carolina, we have discretionary waiver where the judge gets to make the decision, but we do have some mandatory waiver. The example I give here is if you killed someone in North Carolina and you were 13 years and 1 day old, you're going to be tried as an adult. It's mandatory. We're going to waive you over. I can't do a diversion for you. Detention is when we bring you into a secure facility. In North Carolina, that's usually the local jail. And hopefully the jail is going to be separate enough that we're going to have separate facilities. Otherwise, there's predation issues there. You're guaranteed, all things being equal, a detention hearing. And we'll ask, is the juvenile a danger? Will they return? Is he in danger himself? Depending on how those are answered, the detention will or will not continue. The trial. This is going to be determined whether you're in need of some type of supervision. It's really not a verdict of guilt or innocence. So at the end of the adjudicatory hearing, the judge will then rule on the legal issues and evidence that's been presented. And it's going to look like a trial, but it's really not a criminal trial. Not in that way. Because after the adjudication, he hands down a disposition. And he's going to get a predisposition report, and it's going to tell him what his home life is like, of the person arrested, what the parents are like, all this information, and hopefully makes a good decision. This is one area where judges have a tremendous amount of discretion. There's not a lot of structured sentencing going on here. And the judge will look at this, and the judge's personal philosophy and the judge's behavior are all very important. So we have probation. This is the most common thing that happens. Most of them will get out and get probation. And it's very similar to adult probation. About 70,000 are going to go to a correctional facility. And this can be foster care, group homes, rural programs. And again, this can be because we arrested someone who was out after curfew, and it turns out that their parent is irresponsible or has abandoned them. We also can have some aftercare, therapeutic, educational, counseling programs. Again, these tended to be underfunded when I was in better contact with them. Okay, on that, that's about a 15-minute lecture. That's what we like to have here. We've got one more chapter to go, and then I will conclude the course. Hope you're enjoying it.